Hey everybody, welcome to Module 5 already. I want to briefly go over what we're doing this week regarding calendars and dockets. Um, on the surface, this may not seem like something you think fits into our class, but in actuality it does because calendars and dockets are a way of organizing the efficiency of the courts. And that'll become important here in a couple minutes when we talk about some of the constitutional requirements associated with our judicial system, especially when it comes to criminal cases. So this whole topic of calendars and dockets really has to do with how courts are run and their efficiency. At how they're run, and as we have discovered this last week, when you look at the roles of those people that are part of the court process, we also look at those roles in terms of efficiency. Okay, I can tell you as a police officer, and those of you in the class who are police officers as well might have some stories to tell too. But I can tell you many times that, you get off work, you get off graveyard, for example, and then you have to go to court and you sit around and wait, and you wait, and you wait, and then you're finally told you can go home because maybe the case has been continued or the parties have reached an agreement, a plea deal regarding the defendant. So the fact that the courts need to be efficient and effective boils down to calendaring and docketing. And that's, again, what we're going to focus on for a little bit today. So in this module, you're going to read some extra material on calendaring and docketing in the module. So please make sure you allow yourself time to read through that so you become familiar with what we're talking about. We say calendars and we say dockets, right? Because I think that you need to make the distinction between the two. Calendars will include such thing as pretrial conferences and maybe some motions, meetings with lawyers, and meeting with judges. So on the court's calendar are those type of activities. Docketing, on the other hand, has to do with scheduling trials, scheduling the cases to actually appear in court, get ready to go. And these are usually handled by the court clerk. Okay, the court clerk usually handles the docketing and the calendaring of the courtroom. Some of you last week, in last week's assignment, you were able to interview court clerks, for example, or other types of court personnel that were involved with not only the calendaring but the docketing process. And hopefully the goal was that you learn that court administration is what Module 5 is going to be about, the efficiency of running the court system. And like I said, this will become crystal clear in just a minute when we spend a little bit of time talking about constitutional requirements in terms of defendants' right to a speedy trial and so forth. So this week, the written material, you're going to explore both the record-keeping function for both the state and federal courts. So as you work on your assignments this week, we're going to be looking at comparing federal and court systems in terms of calendars and dockets. So the easiest way to do that is to perhaps call up your local courthouse on the internet, look at their docket, look at their calendars, see what it's all about. Then you can take a look at the federal system and see what the federal system is all about. Because this is all going to go down to the emphasis on judicial efficiency and its impact on justice. Okay? I will tell you from a personal perspective, in appearing both in federal and state court, The federal court does a lot in terms of trying to dispose of cases other than going to trial. So there are conferences that take place, and this is both in criminal and civil cases. My experience has mostly been in civil cases where the city has been sued or one of my police officers has been sued. And so the federal courts go to great length to try to resolve those issues through calendaring, where the judge will actually meet with the parties and try to hopefully reach some level of resolution so that the case doesn't actually go to court. So these ideas of calendaring and dockets play a huge role in the efficiency of the courts as it attempts to met out justice. So there is a constitutional requirement regarding criminal trials and the speediness of those trials, and that's going to be the Sixth Amendment. The Sixth Amendment holds that criminal trials be done as quickly after charges have been brought. So it's going to depend on your state and what court you're in. So for example, if you've been arrested for a violation of the law, let's say at the state level, the state has so many days or hours in which to bring charges against you. So for example, in California, it's 48 hours, 2 days. In some states, it might be 72 hours. Okay, and our founding fathers wanted to make sure that with this new constitution, because of the history with England, that people who were arrested had to be charged within a certain period of time and really had to have their day in court within a reasonable amount of time. And we'll talk about more specifics here in just a minute. So the Sixth Amendment clearly describes that, all right, that criminal trials, arraignments, those type of things have a time frame, a period of time in which those things must take place. So that's one of the important things that I want you to get out of this whole idea of calendaring and docketing, is that it allows for that efficiency to take place. So a speedy trial, what is it? Now, a speedy trial doesn't mean the next day, because in some cases, you don't want someone accused of a crime sitting in jail for years waiting to be tried. At the same time, you don't want people to be tried for an offense in which the defense lawyer has not had an ample opportunity to prepare one's defense. And so this is sort of a mix between, you don't want somebody sitting in jail too long, but at the same time you have to have enough time for a lawyer to prepare a proper defense, go through the evidence that is being presented in court, and try to come up with a strategy in which to defend his client against the charges that the state has brought. And so this is why we have the Sixth Amendment. We have the Sixth Amendment so that people don't languish in jail for periods of time before they are brought to justice. That's not how the system works. And so organizing calendars and dockets provides for that efficiency. And especially in criminal cases where, as I previously mentioned, there is a time frame in which those things have to take place. So what is a speedy trial? It is really going to be case specific, because we've had cases, and you are probably aware of cases where a murder trial, for example, the defendant finally gets a day in court 2 years later. And in some cases, it goes relatively quickly. So they are going to be case specific. They are going to be function under the idea of statutory guidelines. There has to be guidelines so that all the parties are aware of, and the case is processed in a timely manner unless a defendant, for example, waives his right to a speedy trial. And so there are those statutory guidelines. For example, in California, if you've been arrested for a felony charge, by statute, you are entitled to a preliminary hearing within 10 days. Oftentimes, that does not happen because the defense attorney needs more time to prepare the case. And so the defendant waives that 10 days, but the defendant does that. Okay, so remember, we got Last week we were talking about rock, paper, scissors in terms of who holds the most power. Well, keep in mind that under those type of provisions, a defendant could say, no, I want to go to my preliminary hearing, and the lawyer would have to put on the best case he probably could based on the time. So again, speedy trial is going to be case specific. There are going to be some statutory guidelines, and there's going to be a limited amount of time in which a person is going to be sitting in jail. And that's one of the big issues here with regarding the speedy trial, is the amount of time a person is in incarceration until he or she is charged with a formal crime. The Speedy Trial Amendment has to do with the trial itself. How does this amendment, which seems to import individual efficiency, impact justice? Well, remember that a hurried trial isn't always fair. In other words, trying to push a case through before the parties are ready isn't fair. The defense has to have time to go through the evidence, prepare whatever type of legal defense they think they can. And so just because we have statutes doesn't mean that trials need to be hurried. And oftentimes that's where the good advice of the lawyer comes in, so that as you prepare your case, you are, as a defendant, then you are able to make a good choice. But oftentimes, anytime you extend the speedy trial waiver, you're doing so knowingly, and so that's part of the key process. But again, it does add a certain amount of efficiency. But then again, continuing the case is going to hamper the court progress. It's going to hamper the calendar. It's going to hamper the docket. So eventually, the parties have to be ready to go. What we want to balance in this case, in terms of dockets and calendars, is we want to balance between efficiency and justice. That is what this module is getting at. This module is seeking you to understand that we have to read the balance between efficiency of the court system and justice. We can't be too quick, because then we might have some injustice. At the same time, we can't lag cases on forever, so it seems, with the sense of achieving any type of justice. So I think that's important to remember. Okay. So our particular case study that we have involving our bank robbery. Remember, this is a federal crime, not a state crime, as we've talked about. So keep that in mind. Although you will have to discuss state docketing and calendaring, but keep in mind the key personnel that are involved. And again, some of this you learn through your more recent activities in terms of your interview process. Okay, so keep that in mind as you go through some of these key situations. This week in our Module 2 assignment, what you're going to do is you're really going to look at judicial efficiency of the court system based on the ideas of calendars and dockets. You're going to be looking at the state courts. And state courts are all different, so there's no typical procedural process for calendaring and docketing. So what you might want to do is take a look at your state court, and that will be fine. Since our case involves a bank robbery, we've already determined that a bank robbery is a federal case. As you look at the state position in terms of calendaring and docketing, it's going to be more of an academic process, because remember, we're looking at federal cases here because our bank robbery took place in Washington, D.C. And so that's going to be the federal process. But we also want you to just become familiar with the state process in terms of calendaring and docketing. A lot of states are going to the federal system in terms of following their guidelines as far as docketing and calendaring and trying to resolve cases to be more efficient and more effective. And so they're following their rules and their procedures. Now, when you look at the federal court system, if you go to any of the court systems in the federal district courts, for example, maybe the one where you live, the first page is about how we do stuff at this courthouse regarding filing motions and filing paperwork. That's to have it be more efficient and effective. So with the advent of computers, it has saved court clerks a considerable amount of time, and now we no longer have to copy documents. That's done online. Okay, so good luck this week. If you have any questions, let me know.